Hello everyone, I'm Dr. Kalpana. Today we are going to learn about Recovery of Debt and Bankruptcy Act. As debt is something which is the main business of banks and financial institution and interest earned on a debt, which is commonly known as loan. So, Recovery of Debt and Bankruptcy Act, initially it was known as Recovery of Debt due to Bank and Financial Institution Act, which was enacted in 1993, but was renamed in 2016. So, this act addresses the challenges bank and financial institution face in recovering loans and enforcing securities, which are collaterals while loans are granted by the NBFCs and banks. Narsimha Committee was constituted to uh, draft the recommendation, what sort of remedies can be provided through enactment. And that committee in 1991 advocated for establishing of debt recovery tribunals and debt appellate tribunals, which are in short are called DRTs and DREDs, to streamline the debt recovery. So currently in India, there are 39 DRTs functioning and 5 debt recovery appellate tribunals. So before going to these tribunals, jurisdiction, power, and constitution, we need to know what is debt as per law and as per this act. So Section 2G of Recovery of Debt and Bankruptcy Act defines debt as any liability, including interest, claimed by a bank, financial institution, or consortium from any person or pooled investment vehicle. And this includes secured or unsecured debt also. And those assigned payable under court order and arbitration, other mortgage legally recoverable on application date, and it also covers unpaid debt securities after 90 days notice. So in case notice has been served and 90 days time has passed, then that debt can be application can be filed for that recovery. So now what is debt security? Section 2GA defines debt securities as debt securities listed in accordance with a regulation made by Security Exchange Board of India under Security Exchange Board of India Act 1992. So not going into details, so debt, in short, you can understand what is a debt is a kind of liability. It may be in any form which is due upon a person as a debt. Establishment and composition of tribunal. So debt recovery tribunal, section 3, subclause 1 empowers central government of India to establish DRTs to exercise jurisdiction, power and authority under the act. And section 3, 1A mandates central government to establish number of debt recovery tribunals and its benches as it may consider necessary as per the requirement. Because earlier we were having 33 DRTs, now we are having 39, and it may increase according to the requirement in future. Composition of tribunal has been provided under section 4.1. Says that tribunal shall consist of one person only, hereinafter referred as to presiding officer, means we do not call him as judge. The person can be called in short, we call it PO, but presiding officer calling makes you clear because PO stands for many other abbreviations also. So to be appointed by notification by the central government. So central government is appointing authority so far as presiding officer of DRT is concerned. The qualification of presiding officers uh, is provided under Section 5 of the Act, which states that a person shall not be qualified for appointment as the presiding officer of a tribunal unless he is or has been or is qualified to be a district judge, meaning thereby, according to Section 5, a person should have the qualification as can be appointed as a district judge. It should not be less than that, it can be more. Debt Recovery Appellate Tribunal, Section 8, Subclause 1, authorizes a central government to establish a debt to exercise jurisdiction, powers, and authority to confer on such tribunal by or under this Act. Actually, these appellate tribunals are established to invite or entertain applications by the aggrieved party, whoever is agreed by the order of DRT. Section 9 talks about composition of debt. That states appellate tribunal shall consist of one person only, hereinafter referred as chairperson of appellate tribunal. So presiding officer of debt is called chairperson, to be appointed by central government. So central government is an authority to appoint chairperson of debt recovery appellate tribunal. So qualification is provided under Section 10 of the Act, which says a person must be a High Court judge, a Grade 1 member of Indian Legal Service for at least 3 years, or presiding officer of a tribunal for at least 3 years. So three kinds of people can be appointed as chairperson of DRED according to Section 10 of this Act. Now coming to jurisdiction and power of tribunals. So here jurisdiction are of two kinds. Here the important jurisdiction is pecuniary jurisdiction. Pecuniary jurisdiction means what amount of debt should be there to file an application to DRT. So first we would know who is having locus standi, or the person who is entitled under this act can approach debt recovery tribunals. So here it is very clear that this act is designed to help and to give remedy to the banks and financial institutions who are facing problem in recovering the loan and interest. So only banks and financial institutions can approach debt recovery tribunals to recover debt, while other borrowers, guarantors, or any other person agreed by the action of the bank or financial institution under SURFACE Act 2000 can approach. They can invoke SURFACE, not this act actually. DRT powers have been provided under Section 17 of this Act, which confers power on DRT to entertain and decide application from banks and financial institutions to recover debt. Pecuniary jurisdiction has been provided under Section Subclause 1. Subclause 4 specify that Act does not apply if debt is less than 20 lakh. Earlier, it was 10 lakh. In September 2018, it was amended and now it is 20 lakh. So any claim by the bank or any financial institution which is 20 lakh or more than 20 lakh can only be filed an application under any debt recovery tribunal, otherwise not. Section 18 is important to remember, which bars jurisdiction of any civil court or authority for recovery of debt except High Court and Supreme Court while they exercise their writ jurisdiction. Now coming to what is the procedure of filing the cases and appeal under this Act. So application to the tribunal can be made under Section 19, which provides bank or financial institution may apply to the tribunal within whose jurisdiction the branch maintains the account. The defendant resides or works or cause of action arises. So there are three kinds of um, options have been provided by Section 19 under this Act, where the dependency is upon where defendant means against whose application has been filed, who's a debtor, and maintains the account, resides or works, or cause of action arises. Section 19 allows for electronic filing of application, documents, and written statement authenticated with digital signature because of Information Technology Act 2002 makes it little easy process for both of the parties while they are approaching DRT all the time. For every work, you do not need uh, to come in person. So it makes a little easier procedure for both the parties. Appeal to appellate tribunal has been provided under Section 20, subclause 1, which allows any person aggrieved by the tribunal order to appeal to an appellate tribunal within 30 days of receiving the order copy. So time limitation has been provided under Section 20, subclause 1. Order when the order has been passed. If 30 days have been passed, then it is barred. So parties has to take in consideration that within 30 days of the receiving the order copy, appeal should be filed. The important question is of what is the mode of recovery. For example, an order has been passed by the DRT or DRET in favor of the bank or any financial institution. Then what can be the mode of recovery? That is a big question and challenge when it comes to how to recover that money or entitlement which has been passed in favor of financial institution or bank. So attachment and sale, a recovery officer is appointed here, can attach and sell the movable or immovable property of the defendant in order to recover that debt. Secondly, possession of property, taking possession of property over which security interest is created or any other property of the defendant and appointing receiver for such property to sell the same. Thirdly, arrest and detention is also one of the mode of recovery if first two are failing to recover the loan. So recovery officer can arrest the defendant and detain him in prison to compel him to give away that repay the debt. Appointment of receiver. So appointing a receiver for management of movable or immovable property of the defendant is also one of the process which is followed while an order is passed by DRT in favor of the bank or financial institution. So now to conclude here, today's key takeaways from this lecture. This act was passed to streamline process of debt recovery for banks and financial institutions through specialized tribunals. So keep in mind one thing, this act is especially enacted to provide remedy in case of default by the debtor for banks and financial institutions, not for private individuals. DRTs and RET have specific jurisdiction and power with limitations on civil court intervention. Section 18 bars the jurisdiction of civil court to entertain any such application which can be covered under Recovery of Debt and Bankruptcy Act 1993. Multiple recovery modes have been provided, can be employed, various methods including property attachment, arrest, and receiver's appointment when it comes to how to locate a mode of recovery, because that is the biggest challenge when a bank or any financial institution wins the case in DRT or DRET. So with this, I would end here. Happy learning. Thank you so much. Take care.